Continuing on our discussion on understanding the basic principles of contract law, uh, trying to lay down the foundation of understanding the law on contracts, we have to understand that contracts come from the law of obligations. You will notice that as we discussed previously, one of the simplest definitions of understanding contracts is that it is nothing but an exchange of promises between two parties. And that's why we say contract law is law of promises as well. And you would notice that when two parties make promise to each other, it could be the promise of the seller to the buyer, there is an obligation that is incurred as soon as the promise is made. And this obligation, you will notice, friends, is important. It is an obligation that you owe to the other party because the other party will now have expectations of fulfilling the promise. And hence, when we say the laws of obligation, friends, you would notice contract law actually is a branch of the laws of obligation. But broadly, if you just want to understand the laws on obligations, we have two obligations that we generally discuss. One is moral obligation, the other is contractual obligations. Friends, moral obligations are based on high value systems in a given society. These are moral obligations that men and women have to fulfill in society. And these are obligations probably that are laid down by personal or religious laws. Now, moral obligations are very, very significant. There is no doubt about the significance of moral obligations, because if you look at it, sometimes moral obligations are more valued in society just than by legal obligations. But moral obligations are, it's a choice. Depends upon the consciousness of a given individual. He can actually follow the moral obligation or he need not follow the moral obligation. For example, we say there is a moral obligation to stay married, right? But of course, divorce can definitely happen. So these are moral obligations that we look forward as a man and a woman in a marriage to be equal partners. But the legal obligation is that, please note, the man has to maintain the woman. So this is a legal obligation that we often speak about. Now, you will notice that the aspect of maintaining a wife, or even today as we speak about maintaining your parents, there is a law that imposes obligation on citizens to maintain their elderly parents. The necessity of bringing the legal obligation is because the moral obligations were not being fulfilled. Now, you will notice, friends, that the morality of an individual would always say that he cannot abandon his parents or his wife even after they have separated. If she has no means of taking care of herself, I think every man in a society is expected to provide for the lady and expected to take care of his parents. Didn't the parent take care of him when he was a child? And shouldn't the man take care of his parents when they are aged or they have become elderly? So the moral obligation was already there. But unfortunately, when the moral obligations are not going to get complied with, are not going to be enforced, are not going to be fulfilled by persons in a given society, then there is a law that actually converts that moral obligation into a legal obligation. Interesting difference, you will notice that in contracts, let's assume why the discussion is present. Friends, isn't promise to be fulfilled? So when you make a promise, shouldn't you fulfill that promise, right? Now, everyone will understand that promises are to be fulfilled and there is a moral obligation to complete what you have promised to the other party. Interestingly, friends, we always can say that these contractual promises are also called as gentleman promises. Gentleman promises, which means if you are a gentleman, you will actually complete the promise and you don't need law to enforce your promise. This is a moral obligation, right? If you have no intention to fulfill the promise, don't even make a promise, right? But that moral obligation, friends, you will notice that does exist, has to be converted into a contractual obligation, a legal obligation. And that's where the law of contract actually came in. It said, look, if promises are not going to be fulfilled, because people don't care about morality, people don't value this, and they're at their free will of breaching that moral obligation, then we'll have to bring in a law and say promises shall be enforceable. The law will bring about an obligation and recognize that obligation, and any breach of the same is going to be provided with some kind of remedies. So I think it's about understanding contract law from the premise of obligations, and you will notice, like I said previously, some of these obligations are either externally imposed, or many of these obligations are self-imposed. Now, please note, contractual obligations are self-imposed, right? You can take it, you need not take it. It's not something that the law always expects you to do. So if you're willing to take it up, please go ahead and do it. But remember, some of the contractual obligations is imposed by law, and these we would say as quasi-contracts, right? Whether you like it or not, the law wants you to fulfill some of these obligations, right? So you would say that mostly contractual obligations are self-imposed, rarely the contractual obligations are externally imposed. So we will talk about quasi-contracts later on, and please note, in government contracts and in understanding special contracts, quasi-contract plays a very, very important role, and the next principle will tell you why that is very important. So I think understanding the basic law on obligation helps us understand the law of contracts, because it did help us understand the evolution of contract law as one of the laws that fulfills obligation. It is one of those laws that promotes promises. It's one of those laws that recognizes that promises have some legal system, legal value, and any breach of the promises must have consequences, must have sanctions, and must have remedies. Friends, contract law is based on the bedrock of two very interesting principles. One is the law of unjust enrichment, and second is the law of restitution. Friends, the law of unjust enrichment is a principle that governs contract not only at the stage of its formation, please note, because we say contract law has three stages, please note. One, the contract law that defines the stage of formation. Two, the contract law that defines the stage of performance, because there is a lot of sections in the Indian contract law that actually define the rules of performance. If you want to refer to section 37 to almost to section 75, including the law on damages, all of them can actually be attributed as the rules of performance. So how should you perform once you have made a contract? So three stages. One, the formation of a contract, the rules, right from section 2 to section 36 are the rules of formation. Then you have the rules of performance of a contract, and 3, you have the rules of breach of contract. So if parties do not perform and they fail to perform, there is a breach. And so what happens in case of breach is the third stage. Now, interestingly, the law of unjust enrichment, or the principle of unjust enrichment, friends, applies to each of these three stages. Look at it: just enrichment and unjust enrichment. Friends, just enrichment is possible. You are allowed to do it. Everyone has the right to profit, because contracts is about commercial transactions. You are in market, you are in trade, you are in economy. You have every business to actually perform, get into profits and enrich yourself, right? Just enrichment vis-a-vis unjust enrichment. Interesting difference. The law actually has to step in when just enrichment seems to be exploited. Just enrichment seems to be abused. Just enrichment is now going to be unjust. Friends, unjust enrichment is a principle for judges, the courts, to intervene in contracts. If they find that one of the parties of the contract is exploiting the other party, he is making unjust enrichment. Now, please note, enrichment is not necessarily monetary enrichment. It could be enrichment of a higher amount or quantity of goods. It could be even that, right? So it's not only monetary. It could be anything of that sort. So unjust enrichment very clearly says that, look, you should enter into contracts. You should make promises, but I think it should be a win-win situation for both the parties. One person cannot dominate the contract in such a way that he runs away with everything that is there in the contract. Right? So Unjust enrichment is the rule to intervene, to moderate, to kind of temper down any such contract which can actually give undue advantage only to one party as against the other party. Right? So the principle of unjust enrichment, friends, you will notice is almost applied in most cases where the courts want to intervene and hold a contract to be voidable and to actually remedy the aggrieved or the party that feels aggrieved from the contract and the unfairness in the contract. The second principle, friends, is the law on restitution. Now, the law on restitution is also very important because please note, very often than not, the duty of the court is that when parties litigate, the parties bring their grievance before the court because the contract is unfair, it's one-sided, it's arbitrary, it has caused a loss to one party, then the court will have to put a rule of restitution. Wherein, what does the court do? The court tries to remedy the wrong. Right? So restoring the party to a position where the wrong can be negated or remedied is what is the duty of the court. So the law of restitution actually speaks about the kind of remedies for the breach of obligation. If a promise is not fulfilled, how should a party be restored with the kind of remedies or rights that the lawyer recognizes? So the law of restitution is also very important, and you will notice that there is nothing like an absolute restitution, but yeah, the courts do apply the principles of, let's say, damages, principles of specific performance. Today we are talking of the principles of substituted performance. We can talk about the suit for price. We can talk about the right of lien, and so on and so forth. So there are many such restitutory kind of remedies that the parties can actually seek in a court of law, and that is how you will notice that the obligation is kind of enforced in the court of law. The court actually comes to the rescue of the injured party or the aggrieved party and actually puts him in a position as if no contract has been made. Right? So that's probably what the court attempts to do. So the law of unjust enrichment and the law of restitution, friends, is the guiding principle for contractual obligation. And you will notice that the duty of the court is to ensure that contracts result in a just contract and a fair deal between both the parties. And the legal system protects the interest of not only the parties, but also the market, the economy, and vis-a-vis the country as such. So, what does the court do? It lays down the principle for contractual obligation. Right? So that's the duty of the court. So that's why you notice that contract law is not only about the act, it's about the doctrines and the principles that the court have evolved from time to time. And these principles guide the application of contract law as we go forward. Now let's take one assignment just for our understanding. I would want you to think at this point of time whether a will is a contract. Now, let's understand what a will is. Friends, a will is a kind of a declaration of an individual who intends to give his property after his death to probably someone who is surviving the drafter of the will. Now, please note, will is your declaration of intention. What should happen to your property after your death? That's what is the expression of the will, right? Now, please note, it is kind of an expression. It's kind of a promise. It says that, look, after my death, this is what will happen to property. So it's kind of a commercial kind of a transaction with an expression of intention. There are two parties to the will, and the will can be registered, need not be registered. And in India, I think it plays quite a significant part in how the property is going to be managed after the death of an individual. Now, interestingly, you will notice that we talk about inheritance of property, right? Where the people who are children or the surviving spouse can actually inherit the property of the deceased. So inheritance of property is kind of a law that actually provides succession to property, and this is quite an important principle as we go forward. Now, can will be considered as a contract? can will be brought under the contract law? Does it fulfill all the essentials of a contract? And suppose there is a breach of will, can parties actually litigate under contract law? So this is something that one will have to probably answer at this point of time. Now, please remember, will is covered under the Indian Succession Act. It's not covered necessarily under the contract law. Now, the Indian Succession Act does, talk about the different attributes or requirements of will, and it very looks, will resembles a contract. It looks like a contract. It's like, I'm giving property to someone else, and this is a transaction. It's commercial transaction. It's an expression of my intention. Probably it's an expression of my promise to my son. Or please remember, will can be to family members, or will can actually give property to someone else as well, right? So we have seen a lot of controversial will in India, and a lot of litigation that have gone to the court on whether the will is right, wrong, was the will done under coercion, undue influence, so on and so forth. So it's kind of a similar litigation that will has looked into, and that's why many of us may think that will is nothing but a contract. But the distinction between will and a contract is something like this, friends. While will is covered under Indian Succession Act, contract is covered under Indian Contract Act. So I think there are two laws differently that govern, and will is probably into a special legislation altogether. Point one. Point two, friends, you will notice that the will actually comes into reality after the death of an individual. So it's not something that comes into execution as soon as the will is made, right? Contracts are actually executed simultaneously, most often than not. So that today, if I sign a contract, I probably transfer the property today itself during my lifetime, right? The purpose of the will is slightly different, right? And the purpose of contracts are slightly different. Now, in most contract films, there is a consideration that has to be supported in contract. Will probably does not have consideration at all, right? So while will looks like a document close to contract, it's not necessarily to be treated as one, right? So we have to remove will from contract law and actually treat it under some other legislation, and the remedies of contract are not necessarily the remedies that are going to be applied for it. Because remember, if suppose what is written in the will, and if it's written in my favor, is not done, whom will I sue, right? Because the executor of the will may be appointed, but the drafter of the will is already died. So I can't sue him for breach, saying that, look, what you've written, I have not actually got it. Your promise is not going to be fulfilled. So, I can't sue the deceased, drafter of the will. So I think there are numerous reasons why we want to treat will differently. And hence, there was a statute that was enacted to treat will, and hence this was taken out probably from the domain of contract law. And you will notice that contracts today are different. They have a different contextualization, and will is not considered as a contract. Right? So just a kind of evaluation of relationships and evaluation of documents in a society for a better understanding of what it is.